Your Honors, and if it please the Court, my name is Randall Young. Now, on behalf of Thomas and Carol Smith, I'll be arguing three things today. First, that the Yuma Indian Nation waived its sovereign immunity multiple times. Second, that the EDC is not an arm of the tribe and therefore does not enjoy the protections of sovereign immunity. But even if it does, it waived its sovereign immunity. Finally, the EDC's officers are not immune from suit. On this first matter, the United States Supreme Court ruled in Oklahoma Tax Commission versus Citizens of the Potawatomi Tribe of Oklahoma in 1991 that for a tribe to relinquish its sovereign immunity, it has to do so clearly. The question before this court is what is clear? Should it look to federal case law, the law governing waivers of sovereign immunity by foreign nations, and state authorities, it will find that the Yuma Indian Nation waived its sovereign immunity by the terms of the contract that it signed with Thomas and Carol Smith.
Counsel, under the Yuma Indian Nation Tribal Code, isn't this court commanded first to look to tribal law before it looks to federal law on these questions?
Yes, Your Honor, this court should absolutely, of course, look to its own tribal code first.
And doesn't the tribal code itself expressly make the tribe, its employees and officers, as well as any corporation wholly owned by the tribe, immune from suit?
Yes, sir. It does. Yes, Your Honor.
And isn't that dispositive in this particular case?
No, Your Honor. The Smiths would argue that the question before this court again goes to the precedent set by the United States Supreme Court with regard to clarity. And while tribal statutes will go to that clarity inquiry, nevertheless, there are a number of other factors that this court should look at in answering that clarity inquiry.
But before this court, is the question of sovereign immunity governed by tribal law or federal law?
Your Honor, by both. And in this respect, this court should look first to analogizing the contract language that the Yuma Indian Nation signed with Thomas Smith to the contract language in CNL Enterprises versus Citizen of the Potawatomi Indian Tribe decided by the Supreme Court in 2001. There, the court had to answer those sort of open question left by the Oklahoma Tax Commission regarding what is clear. And in that instance, the Supreme Court had to evaluate an arbitration clause, the terms of which providing that arbitral awards could be reduced to judgments in any court having jurisdiction. Now, Justice Ginsburg, who wrote for the court, noted that the tribe memorialized its commitment to a dispute resolution regime. And in that case, again, the court found clarity. Similarly,
But didn't a clause in that case authorize the enforcement of the award?
yes, Your Honor.
In this case, is there any authorization for the enforcement of anything in the contractual clause?
Your Honor, the Smiths would argue that the authorization by the tribe to litigate any and all disputes in a court having competent jurisdiction is such an acquiescence. And
the CNL was a question of whether the state court could have jurisdiction over this because of that clause. But here, there's an agreement, any court of competent jurisdiction. That may or may not confer jurisdiction on the state court, but doesn't it clearly? The real question here is whether it confers jurisdiction on the tribal court.
absolutely, Your Honor, and that is, the contract language here can kind of cut both ways with regard to these separate questions. And as my co-counsel has argued, while the language does say a court having competent jurisdiction, a review of the case law will indicate that this court simply doesn't have personal or subject matter jurisdiction to hear the case, and therefore, in the strictest sense, it's not competent in that jurisdiction.
Does the tribe waive its immunity by suing in its own court?
Your Honor, yes, and this court should look to case law before Oklahoma Tax Commission. Particularly, it should look to the analysis of Rupp versus Omaha Indian Tribe decided by the 8th Circuit in 1995. And in that case, the court noted that when a tribe initiates an action, it necessarily consents to that the court's jurisdiction, rather, to hear adverse claims against it. Now, Oklahoma Tax Commission, in that case, of course, the Citizens of the Potawatomi Tribe sought injunctive relief against the Oklahoma Tax Commission in a state court to prevent the tax commission from levying certain taxes. Now, that was seeking equitable relief, a form of an injunction. And this court can easily fashion a rule that reconciles earlier case law with the rule of Oklahoma Tax Commission. And in a sense here, the Yuma Indian Nation has sought money damages against the Smiths for various breaches of fiduciary duty, breach of contract, and things like that. So this court could absolutely carve out a rule. Now, should this court decide that it's not interested in butting heads with Oklahoma Tax Commission, this court could very easily construe the Smiths' counterclaims as claims in recoupment. And this is an equitable defense. This is not an affirmative action by the defending parties to get at the plaintiffs.
The movement would be limited then to anything that the other side has recovered, isn't that right?
Yes, Your Honor. Yes, Your Honor, and the Smiths are, all the Smiths are asking for are, they have claims for defamation and wages due under the contract. And while on the merits, the trial court might have to make a determination as to whether defamation fits within the standards for recoupment, it seems a pretty clear-cut case that wages due under the contract meets the equitable inquiries for a recoupment claim against the Indian Nation should this court determine that it has jurisdiction in the matter. But going back to the Indian Nation's waiver by the terms of the contract itself, this court should look to Kiowa Tribe of Oklahoma versus Manufacturing Technologies Incorporated, decided by the Supreme Court in 1998. And in that
Counsel, Carroll and the tribe aren't in privity of contract at all, are they?
no, Your Honor.
And so could there be a waiver with respect to her?
If I understand Justice Clinton's question properly, whether or not the tribe had waived in the contract terms it had signed, yes, Your Honor. Yes, because the reason why is that Carol Smith's contract by and through Thomas Smith was specifically under the terms that Thomas had signed with the Indian Nation. And it's a fair extension that since Carol Smith was providing services to her brother who was working under that same contract with the Indian Nation, that they waived insofar as the damages that they have incurred against her, the defamation of wages.
If you're arguing that we should do that for Carroll for purposes of the sovereign immunity claim, well, I recognize that it's not your issue. Shouldn't we do precisely the same thing with respect to the jurisdictional claim?
Your Honor, if this court does find the existence of a contract, I think that co-counsel has argued that even in the potential existence of a contract in and of itself, it doesn't necessarily muster enough for this court to find personal and subject matter jurisdiction with regard to Carol Smith. And so going back to this question about the terms of the contract, in Kiowa Tribe of Oklahoma, the court did note that looking for law governing waivers of sovereign immunity by foreign nations is instructive in its analysis. Specifically, the Supreme Court noted the third restatement of the Foreign Relations Law of the United States. Specifically, that section noted that any time a sovereign entity agrees to arbitrate, it waives its sovereign immunity insofar as the matters that it agreed to arbitrate. While this is a third restatement, it is absolutely persuasive. It has no binding authority on this court. In fact, all the authority we're mentioning today is only persuasive since it's a tribal court. This court should look at the analysis and the principle underlying the third restatement of the law governing foreign relations. And in that instance, the Indian Nation, by agreeing to litigate any and all disputes relating to the contract, it's agreed to waive insofar as these matters relating to the contract.
Doesn't section 11-1003 sub 3 provide the exclusive means by which EDC can waive its sovereign immunity?
Yes, Your Honor.
And are the facts of this case consistent with that tribal court provision?
Your Honor.
Tribal code provision, excuse me.
Your Honor, it's the Smith's position that the EDC is not an arm of the tribe, and therefore, from the initial point from ab initio, that this is not the EDC is not entitled to the protections of sovereign immunity.
But given that the code specifically says when a corporation is wholly owned by the tribe, these requirements have to be met, isn't this court, as the tribe's highest court, bound by that code provision?
Yes, Your Honor. It is in fact bound to honor that code. However, it should note that upon review, the court would have federal district court on post-exhaustion would have to review the question under the standards of the Ninth Circuit, specifically White versus University of California, decided by the Ninth Circuit in 2014.
Do you have any authority for the proposition that a federal court can review a sovereign immunity decision as opposed to a subject matter jurisdiction decision after the tribe has rendered it?
Your Honor, a case on point that does not initially come to mind, FCIS versus the Confederated Tribes of Grand Ron was a post-exhaustion review case, and the district court granted comity to the decision of the tribal court, so it didn't get to any of those other issues on that matter. But this would be an issue that is a federal question, one which the district court would have the ability to review. And this court should look to the factors test adopted by and through White versus University of California.
How, if at all, does this question arise under federal law to give the federal district court subject matter jurisdiction?
Your Honor, the tribes a tribe's sovereign immunity is a question of federal law. This court, which would meet those requirements, yes, sir. And so, looking to those factors, the White versus University of California adopted a factors test that was initially developed by the 10th Circuit and Breakthrough Management Group, incorporated for the Classic Gold Casino and Resort, decided by the 10th Circuit in 2010. And that court looked to a number of 6 factors to determine whether or not an economic entity constitutes an arm of the tribe and therefore enjoys the protections of sovereign immunities. This court should look to a handful of those factors, even though while no single one is dispositive. This court should focus its analysis on the financial relationship between the tribe and the EDC, as well as the structure, ownership, and management of the economic entity. Specifically with regard to the structure, ownership, and management, the EDC Board of Directors has 5 members. 3 of whom must be members of the tribe, but 2 of whom must not be members of the tribe, either non-members or non-Indians altogether. And the standard for being a member of the Board of Directors is not political pedigree or governmental experience, but rather is business acumen. This is an economic entity, one that is not a political or a governmental entity. And while the tribal council does have the ability, on a 75% vote, to remove any one member of the Board of Directors for any or no reason at all, the Board of Directors themselves are the ones who choose their own successors. So while it might ostensibly seem as though the tribal council has an effective veto power over the EDC, the Board of Directors picks their own successors, so it's a hollow veto power. This court should also take notice of the financial relationship between the EDC and the Union Indian Nation. Specifically, the EDC's charter requires that in no way can it ever implicate the assets of the Union Indian Nation. The takeaway for this court is that should it find jurisdiction and should it determine that the Union Indian Nation...
What about the 50% profits that go to the tribe, not to the community?
Yes, Your Honor. The 50% goes both to the purpose as well as to the financial relationship. This court should contrast with the financial relationship in Breakthrough, where 100% of the profits went back to the tribe, and they were specifically earmarked for specific things like a tribal trust program, elder care, and economic programs to reduce reliance on gambling.
And what about the loan? What about the loan? That was fully funded by the tribe.
Yes, Your Honor, and there was a $10 million initial loan, which the EDC had only paid $2 million back. That having been said, this is a loan that would be paid back ultimately at some point. And the payback of the financial, with regard to that financial relationships standard, as soon as they pay the loan back, it's almost a non-factor at that point, Your Honor. In closing, Your Honors, this court should determine that it does not have personal or subject matter jurisdiction. Alternatively, the Smiths would at least ask that they could pursue their claims against the Indian Nation, the EDC, and its officers in this forum. Thank you.